Hi, Todd Orchide here with GTL Real Estate. This week wanted to just do a quick video about fiduciary responsibility. It's probably a term you've heard before but aren't quite sure either what it means at all or how it applies specifically to property management. It's not a term that most people are very familiar with unless they work in financial services or real estate or something to that effect. So there's probably a lot of people out there who are interested in this. Basically, what fiduciary responsibility means is that a person, a fiduciary who has that responsibility to you as a client, is required to handle your situation in your best interest to the detriment of even their own interest. So basically, what that means is they always need to be looking out for you, even if that means that it might make someone mad at them, or it might make them a little bit less money, or whatever the case may be. Their responsibility is ultimately to do what's in your best interest to make sure that you get the best return on your investment. So in property management, what that basically means is when we're managing your property, when any property management company is managing your property, the actions that we or that management company must take have to be in your best interest as the landlord. So that means, you sometimes have to do things that will get a tenant upset at you because you're having to enforce the lease on behalf of the landlord, which might mean collecting a late fee, filing an eviction, refusing to do a repair that is not required by law or isn't justified. Those things will make the tenant sometimes pretty upset with us as the property management company. But we're required to do that because our responsibility is solely to you as the landlord. Our only responsibility to the tenant is a responsibility of what's called fair dealing, which basically means we have to be honest with them. We have to follow the law. We can't tell lies to them, that sort of thing. We can't withhold information that's considered material facts. For example, if we knew the house was filled with mold, you can't tell us not to tell the tenant about that, or a prospective tenant about that. We have to disclose that to them. That's required by law. That's just something that we would have to do. So that's kind of the limit of what our responsibility is to someone who's not our client. So the landlord is our client in a property management relationship. So our responsibility is to you to make sure we represent your best interest. Now, of course, this doesn't necessarily mean that we have to do whatever the landlord tells us to do. Obviously, there's limits on that responsibility. And fiduciary responsibility doesn't mean that we have to follow directions from the client. It means that we have to do what's in the client's best interest. So if the client tells us to do something that is not very smart to do, for example, if a landlord told us, my tenant's not paying the rent, I want you to go and take the front door off the hinges. Well, we're not going to do that because that's illegal, and it's also not in your best interest because it's illegal. So for that reason, a fiduciary responsibility doesn't mean that we have a responsibility to follow directions from the client. It means that we have a responsibility to do what's in your best interest. So in that situation, if you tell me to go take the door off the hinges because the tenant hasn't paid the rent, what's in your best interest is for me to tell you, no, I'm not going to do that. Here's why, and refuse to do that. So, that is what's in your best interest, even though it might not be what you've told us to do. So that's an important distinction there. Another limitation on that fiduciary responsibility is what's in the contract between us. Or between you and whatever management company you may have working for you. So the contract, that management agreement, will have a certain list of responsibilities, duties, limitations on responsibility, all that sort of thing that lays out how that business relationship is going to work. So, for instance, you're required to pay certain fees for that service. So obviously, it could be argued that it's in the landlord's best interest to not charge them any fees if you're a fiduciary. But because we have that contract that says, these are the fees for our services, this is what you have to pay for us to manage the property. Obviously, you would have to pay that because that's part of the contract. Also, the contract will probably lay out certain things about how the management company does business. It might even just have a blanket across the board statement, like ours does, that says the property will be managed according to our normal policies and procedures. A lot of management companies will have that sort of provision in their contract with their clients. So basically what that means is the landlord can't just demand that the property manager do something that's outside of their normal way of doing business. For example, we charge tenants late fees after the 2nd of the month. So if a landlord came to us, one of our clients, and said, I want you to charge a late fee after the 1st of the month, we would say, no, we don't really do that. We want to keep everybody on the same late fee. That's, our standard policy and procedure is after the 2nd they get charged a late fee. And, your contract with us says that we're able to use our standard policies and procedures. So those are kind of the limitations on fiduciary responsibility and what a fiduciary owes to you as the client. So you have to keep that in mind. But in general, your fiduciary, your property manager, your real estate agent, your investment manager, anybody who has a fiduciary responsibility to you, unless you're asking them to do something illegal or something outside of the contract, then that person should be doing what's in your best interest and not in theirs. So, where does this come into conflict sometimes? I see some property managers who will say things like, I'm not going to charge that tenant for that damage they did on move out because I don't want to get a bad review from that tenant online. I don't want to get them upset, so I'm just not going to do that. That would be a violation of that property manager's fiduciary obligation to you as the client. Sometimes those property managers will say, well, I don't file evictions until tenants are 30 days late because it makes it easier for us and it makes the tenants, less angry, that we're not filing evictions quickly, so we don't do that. Now, if that's in their contract with you that says they can do that, they can, but our view is that's a little bit to the extreme side of what should be in a contract. They should be looking out for your best interest and not theirs. Certain limitations, like I said, on policies and procedures are reasonable that any management company should have. They have to have their way of doing business, but it needs to make sense. If they're telling you we don't file evictions for 30 days after a tenant's past due, my statement to them would be, how can you justify that in representing your client? What is the justification for why that's in your client's best interest? And I don't think there is a justification for that personally. So that's not how we do things. So that's sort of what you need to think about when it comes to fiduciary responsibility. The fiduciary, the property manager in this case, should be doing what's in your best interest, not in theirs. Not just what makes their life easy, not what just reduces their costs, not just what makes the tenants happy or whatever the case may be. It needs to have a rational basis for why it's in your best interest as their client within the bounds of the contract that you have with them, of course. So if you have any questions about any of this, send us an email at support@gtlrealestate.com. Our website is gtlrealestate.com. If you want to contact us about managing your property, please feel free to do so. And have a good week.